Hi, good morning. This is Ifoma Odolami from the Odolami Law Firm, and I am here to talk about FAQs in family-based immigration. So I'm going to try to get onto Instagram. I've never done that before, so I hope this works. Let's see, I think I pressed that, I hope. I'm not really sure what to do on Instagram, but let me get started here. And let's see how that goes. So, for those who haven't met me yet, my name is Ifoma Odolami. I'm an immigration attorney from the Odolami Law Firm. I'm also an immigrant, just like you. And so this is why it's so important for me to discuss the things that, the questions that you have regarding immigration, because the main purpose of our firm, our passion, we want to make sure that our clients or people who want to get status in the United States are able to do so quickly and safely. They're able to bring their families over without any problems. And so that's part of our purpose. And like you, because I've been where you are, I know that there's a lot of anxiety that goes on with this. Let me go to the comments so that I can see your questions if you have any questions. So my office is in Cedar Knolls, New Jersey. But we have clients from all 50 states because immigration is federal law. So we're able to take clients from all 50 states of the United States. So today I want to go over some of the questions that I get quite frequently. So that and this is your opportunity to ask questions. Now I have to lay out this disclaimer here. I cannot answer the specifics of your situation because I really don't want you putting all your information on a public forum such as Facebook. And also, you need to know that there's a general rule and then there are specific exceptions based on the situation that you're in. So when I answer these questions, I'm just answering the questions with regards to the general rule. But sometimes that general rule could change based on somebody's situation. So that's why it's really important for you to have a proper consultation. I can't count how many people who have come to my office thinking that they qualify for something, but they actually qualify for something even much better. And sometimes they come thinking they have no chances of getting their papers, and through asking questions, I'm able to dig out more information. And as a matter of fact, I think about it. The thrill of being a lawyer is the fact that we're able to think outside the box. So we have the law, and then you're able to figure out how this law can apply in unlikely situations. And I'll give an example. I had a client who came in. She wanted to file for her niece, and she said to me, "Can I file for my niece?" Of course, the answer is no. You cannot file for your niece. That's not the law, right? But I wanted to know why she wanted to file for her niece. So I asked a couple more questions. I said, "Well, why do you want to file for your niece?" And she said, "Well, her niece lives with her. Her niece's mother, which is, well, her sister had passed away, and the father was never in her life. And the niece lived with her here in the United States." So based on that, we're able to file a SAGE petition because we're able to show abandonment. Death is an abandonment according to the law, family law. Death is an abandonment, and the fact that the father has never been in her life. So she's able to get a green card through SAGE. So when you ask these questions and throw it randomly, can I file for my brother? Can I file for my cousin? The answer is no, because that's the law. However, if your attorney does a little more digging, you might qualify for something that you didn't even know you could qualify for. So that's why it's important for you to have a proper consultation so that you can figure out what your options are, okay? And those are the things that the people who fill out the forms that for you wouldn't know because they're not lawyers, okay? So let me get into the questions that I want to discuss today. I got a question. Somebody asked me, can my stepchild file for me? And the answer is, as long as the step relationship, which is when you married the parent of that child happened before that child turned 18, then in the eyes of immigration, you're the step parent. And now this is a thing, right? Once that child turns 21, they can file for you. And even if you're divorced from the parent, you remain a step parent to that child as long as you keep communications with that child. So even if 10 years after a divorce with a parent, the child wants to file for you, that's your stepchild. So the two things you need to meet is the fact that the step relationship occurred before the child turned 18, not on the date of the child's birthday, before the child turned 18, and that you continue to keep a relationship with this child. And if that's the case, your stepchild can file for you. And as a matter of fact, there are other situations where this relationship with the stepchild, either as a U.S. citizen or if that stepchild is a U.S. citizen or a green card holder, can benefit you in other ways. So this is why it's important to have a proper consultation so that your attorney can go through, figure out what other information is required to put you into a category that would be helpful to you. So another question that I get is, let's see, expiration of your conditional green card. So now let me explain what a conditional green card is. A conditional green card is the green card, it's a temporary green card you get when you're approved and your marriage has been 2 years or less. So in that case, you don't get a permanent green card. The permanent green card is a 10-year green card. What you get is a 2-year green card. And you're required to remove the conditions from the green card 90 days before the expiration of that green card. So sometimes the green card is expired, you get the 18-month letter that gives you an additional 18 months to your green card, and you want to travel and leave the country and you don't know what to do. Well, this is what you do. You must get an InfoPass appointment. You need to call and get an InfoPass appointment so that they can put the I-551 stamp on your passport. You cannot leave the country with an expired green card without that stamp, because that would make it difficult for you to come back. So you want to make sure you have that, okay? Now, let's talk about naturalization. Another segue into this is sometimes you've had a conditional green card and you're waiting to, you've gone for the interview to have it removed, or you've filed for a waiver based on abuse, divorce, or any of the waivers that's applicable, and then you're still waiting, and you haven't gotten any word from USCIS. Now, if you've had a conditional green card for longer than 3 years, you can begin filing for your naturalization, even though you have not received a decision regarding the removal of the conditions on your green card. And as a matter of fact, sometimes when you file for the naturalization, it hastens the decision on the conditional green card, because they have to address that before you get naturalized. So a lot of times when you go for a naturalization interview, the conditional green card and the naturalization is taken care of at the same time. So let's look at another question that I get all the time. So VAWA derivatives. We talk about VAWA all the time. VAWA stands for Violence Against Women's Act. Now, even though the acronym is VAWA, it really applies to both male and female and children as well. So I get this question a lot, right? Can my children get benefits, get their green card if I win if I get a green card through VAWA? And the answer is yes. So even the children who don't live with you in the United States, children who live outside the United States can get their green card based on your VAWA petition. So as long as you file within, as long as they're under 21, they can get that. So if your children are not in the United States and you get your VAWA approved, they can still get their green card through VAWA. Then, there's a whole process to get them over here, but they can get their green card because your VAWA was approved. And another derivatives is sorry, let me step back. If you file as a parent of a U.S. citizen, if you file a VAWA application because your child who's a U.S. citizen and who's 21 and above is being abusive, there are no derivatives, which means that your children, if you have younger children, cannot get the benefit of that VAWA application. It only applies to, it does not apply to parents who are filing a VAWA petition based on abuse from their U.S. citizen children. So that's an important distinction that you need to know. But otherwise, if you file for VAWA, your children can get, under the age of 21, can get the benefit of your petition. And if you have a child who is being abused by your U.S. citizen, their U.S. citizen parent or step parent or green card parent or step parent, even if you are not being abused as the spouse, you can get your green card through that child's petition. All right, and then the children you have who were not being abused, but your children and siblings to the child who's been abused can also get their green card because you can add them as derivatives when you get your green card. So it's a little bit of a maze, but that's how it works. Okay, so let's think of another question that I get all the time. Let's see. Divorces. This is a big one. I wanted to talk about it because I get a lot of people who come in for consultation, and they've been denied because the divorce decree was not considered not valid. They asked to authenticate it, and they don't, and it's the case is denied because the first marriage was not, they didn't provide adequate evidence of a valid divorce. And so I want to talk about this because in the United States, you cannot be married to two people at the same time, right? So if you don't show evidence of a proper divorce, the second marriage that you're hoping to get immigration benefits from is considered void. So it can't give you any benefits if it's not a real marriage. That's why it's important that the first marriage or any marriage that you've been involved in prior to the marriage that you're seeking to get immigration benefits, you have to show that it was properly ended. Now, the only exception is for VAWA, right? If you're married to somebody who's a U.S. citizen or green card holder, and that person made you believe that they were able to marry you because they were properly divorced, but in actual fact they were not, VAWA will treat that marriage as a proper marriage for the purpose of helping you get your green card through VAWA. And that's the exception. So, but it doesn't work the other way if you are the person who doesn't have a proper divorce. So it only works if the U.S. citizen or the green card holder who's the abuser does not have a proper divorce, and you have to show that you thought they were legally able to marry, which means that you believe that they were properly divorced, and you have to show that you were the marriage between you and your abuser was done in a ceremony. Okay, so that's important because I mentioned this because a lot of my Nigerian clients, I'm Nigerian by the way, a lot of my Nigerian clients get in trouble because of those divorces. And the thing you need to know is you can file a divorce from the United States. If you live here and your ex-spouse or your spouse is in Nigeria, you can divorce them from here. In that way you get a valid divorce decree from here. Because what happens is that they hire somebody to file a divorce for them in Nigeria, and that person may or may not do what they're supposed to do, but they will give you a certificate that says that you're divorced, and USCIS, they'll check on it and find that there's no divorce, and then the case that you're basing your petition on falls to the side because you're not in a valid marriage. So I'm not seeing any questions, so I'm just going to go on and then I will get off. So let's talk about let's see. Let me look at more questions. Now let's talk about people that the people that you can file for, because I get this question a lot. Who can I file for? Now there are two categories, right? There's immediate relatives, which means that there's a visa number available for them right away. They don't have to wait. That would be your parent if you're over 21, your spouse, and your children under 21. And you're a U.S. citizen. Those are people are immediate relatives. As soon as they apply, a visa is an immigrant visa is available to them. Now, there's another group of people called preference. Those people have to wait until a visa is available. And those preference is, if you're a US citizen and your child is 21 and above, that's a preference. They have to wait until a visa is available in their category. Then there's a legal green card holders, right? Legal permanent residents who are filing for their spouse and their children under 21 and filing for their children over 21. And then there's the US citizen filing for their married children, and then there's US citizen filing for their siblings. So those are the categories that you can file for your family members, but you have to wait until a visa is available for them. When it comes to filing for your nephew, your niece, like I said, there's circumstances if you're a guardian or the child is living with you here in the United States and that child has been abused or neglected or abandoned by their parents, and you want to become a custodian to that parent to that child, they may qualify for a green card based on special immigrant juvenile status. So that's another category that that child could qualify for. But the important thing about talking to a lawyer is sometimes you don't even know what's available. I had another case where my client came into the country when she came through the border and she was about maybe she was less than 5. I don't even think she knew she was not a U.S. citizen until she got much older. Tried to apply for a driver's license and found out she wasn't a U.S. citizen. So she was married to a U.S. citizen, and they tried to file a petition. But of course, she would have had to leave the country to file for that petition. And when she came to talk to me, we found out another way that she could file her petition without leaving the country. So those are things that meeting with a lawyer can reveal to you. There may be other options for you to stay in the country without having to leave, because a lot of people are afraid to leave because they worry that they may not be able to come back, or they may not be able to come back when they want to come back. And of course, they worry about the family members who may have hardship because they're not living, they're not there in the United States. So I don't have any other questions, so I just wanted to shoot in right here to do a quick FAQ, but I will see you guys next week. Have a wonderful weekend and take care of yourselves.